Good morning. The first case to come before us this morning is In Re NK. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve some time, if you let me know when you get started, I'm keeping track of the clock this morning. Please don't use the names of any victims or minors. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court. Good morning, Ms. Demartino. I would like to reserve 5 minutes rebuttal. For the record, Your Honors, my name is Susan Manowski. I work for the Legal Defender's Office of Summit County, and I represent the juvenile in this matter, NK. Your Honors, this is a case where the trial court took sua sponte action. I know from the state's brief that the state is phrasing this case differently. And so I'm going to address that first. So this is a matter that is subject to de novo review because it is a legal issue. And it doesn't really matter what the trial court decided. What matters is what is the law. And that is why it is an appellate review at the de novo review level. The state has filed a reply moving it to an abuse of discretion standard, which is not what this appeal is about. The juvenile is not appealing whether the judge abused her discretion. The juvenile is appealing whether, as a matter of law, a trial court can sua sponte unseal a juvenile record and then undo a final order that was a dismissal with prejudice that the trial judge signed. So in this particular case, the juvenile and the juvenile's family agreed to a dismissal. That dismissal was presented to the juvenile magistrate and is part of the court record. It was a dismissal with prejudice. A dismissal with prejudice is pretty final. And by law, it leads to a sealing of the juvenile record.
Counsel, let me just interrupt you for a second. I know there was an actual entry that was obviously put on dismissed with prejudice, but was there any actual record? I have not had a opportunity to review the record yet. So was there any transcript that you've presented in regard to that that shows who was in court that day or anything that or was there a hearing or, just what happened there with the record actually?
Okay. There's no transcript. The state did not request a transcript in support of its position. A transcript is not needed in this case because the court speaks through its journal entry. And what the journal entry reflects is the magistrate had the state prosecutor and the attorney for the juvenile, who at that time was somebody other than myself, and that they told the magistrate what the agreement was, which was a dismissal with prejudice. And that was agreed to by the family. Now, note in this case, the alleged victim is the stepfather, who is a family member.
Okay, that's why, let me just stop you again. That's why I was asking about a transcript. So, so we don't have anything before us that demonstrates that stepfather or anyone else in the family was present. I mean, well, maybe in the journal entry, but was present and said, yes, this is our agreement as well. We're fine with this dismissal.
So what is in the record is, if you look through the juvenile docket, is the fact that the juvenile court notified the stepfather of all proceedings, notified the stepfather of his rights. Nobody else was present during that particular hearing. No, he had been present at previous hearings. He had been subpoenaed for trial. And of course, he lives with the juvenile's mom and sometimes the juvenile. But there's no transcript of the actual hearing, the conversation that took place between the state of Ohio Defense Counsel and the magistrate. the magistrate's decision does indicate that nobody else was there, if that's what you mean. So the magistrate made this decision. It was entered on the record. The state of Ohio had opportunity to object to the magistrate's decision, did not do so. It became a court order. The state of Ohio filed a motion to vacate sentencing, which there was no sentencing. And in fact, in juvenile court, it would have been a disposition. But there was never an adjudication. So there was never a sentencing. The trial judge then seals the record as a matter of law. The state of Ohio has never filed anything since the judge sealed the record. There has been no motion to unseal the record. So unsealing the record was done sua sponte. With respect to the state's argument that the defendant or the juvenile did not get an opportunity to have an allocution, well, the state of Ohio does not have standing to raise any such argument on behalf of the juvenile, and the juvenile did not need to have an allocution. The juvenile was never adjudicated. The case was dismissed. So it makes no sense to set the case for a disposition or to argue that somehow the juvenile was denied of an opportunity to say something before the court. The juvenile is not complaining of that. I understand that the state of Ohio may have buyer's remorse. Maybe they neglected to notify the alleged victim or consider what he had to say. And perhaps there should be remedies for that. I think there are. But unsealing a sealed juvenile record and undismissing, if you will, a case is not the proper remedy for that. And the court's order fails to take into account the magistrate's decision. In order to reverse the dismissal, the trial court would have to also overrule the magistrate's decision, which dismissed the case, and that still has not been done. Your Honors, the court speaks through its journal entries. The journal entries in this case clearly show the parties agreed to a dismissal. The case was dismissed with prejudice, cannot be brought up again. No objections were filed. No appeal was filed. And the case was sealed. There are very limited exceptions to the sealing statute. And the trial court cannot unseal a record unless the case fits within those exceptions, which this one does not. Thank you.
Thank you. Counsel for the state?
Yes, may it please the court, Heaven Demartino on behalf of the appellee of the state of Ohio. We are asking that this court affirm the trial court's decision, which was to vacate its original decision to dismiss the case as well as to seal the matter. This state is taking issue with the way that the case is being characterized. In fact, we agree completely that a court speaks through its journal entry, and the journal entry will show that this came up on a file review, which means that the court on its own looked at the matter on a day other than when it was scheduled. So the victim was not notified that there was a file review. In fact, the last journal entry the victim would have received through the court would have been about the trial date. And it's also important to remember this happened right at the beginning of COVID. So things were a little bit, we were still trying to figure out how to deal with things during COVID. Things at juvenile court were still going forward, but with a lot of, limited understanding, I guess, of what this pandemic is going to turn out to be. So this victim was absolutely not notified, and we did not ask for a transcript on behalf of the state because, again, the court does speak through its journal entries. And when the state filed its motion to vacate sentencing, which we acknowledge would be also called a disposition at juvenile court, the motion filed by the state noted that the victim was not given the opportunity to speak at disposition, and the court granted that motion, which in and of itself shows that the state's motion was agreed on by the court. The court acknowledged in its journal entry that that victim was not given the opportunity to speak at disposition. So I don't know why, we got that journal entry and then saw the error in it and a month had transpired. I don't know if that was due to the pandemic. I can't speak to that. What I can say is that the journal entry came out. It did not reflect what the state believed the agreement to be, which was that this juvenile would plead to a disorderly conduct, enter diversion, and there would be an opportunity for the victim to speak. Instead, that journal entry said that the case was going to be dismissed by agreement of the parties and that the family wanted to move on. But that is not accurate. The state wants the victim to have the opportunity to speak. He has that right under Marcy's law. He has that right by statute to speak at disposition. So we're not asking to have this to have this defendant face any type of double jeopardy. We're acknowledging that, this juvenile will go through diversion. We just want this victim to have the opportunity, pursuant to constitutional amendment under Marcy's law and under statute, to speak at disposition. And again, we are asking this court to find that the trial court's journal entry granting the state's motion does show that the court acknowledged that there was an error in the journal entry and that there was an error in not allowing this victim to have his constitutional and statutory right to speak at disposition. So we still would put forth the argument that the standard of review is abuse of discretion. This is not a question of law. This is a question of, did the trial court act within the law when it granted this motion filed by the state? Yes, I see you now. Sorry.
Can you hear us?
I couldn't hear you though.
Can you hear us?
I can hear you now. I could not, no.
Okay. All right. Well, I'm sorry. I was waving and doing all I could, and then I thought, time out.
Technology is great most of the time.
Yes. What I wanted to make sure is, when you're saying it came up for a file review, you're saying that wasn't a scheduled pretrial or anything, and that's whenever the state and the defense had an agreement that they presented to the court?
No,
Okay.
it came up for a file review, and I can't quite tell from the docket exactly why that magistrate decided to do the file review or why the prosecutor and the victim were present, but the journal entry reflects that it was a file review.
I understand that, but that's what I'm saying, and that's what happened for the first entry. That
Right.
when the case was vacated, when the case was dismissed and
Right.
And sealed. Okay. And the state did not object to the magistrate's decision, though.
No, and I don't know if it was a matter of the prosecutor on the case maybe didn't see the journal entry right away, but instead they filed this motion to vacate sentencing was how they handled that.
And that was after the time period had passed for the objections?
Yes, it was a month later.
How do you get over that little hurdle? Because, if, no offense, but if this were the defendant's appeal, it is a defendant's appeal, but if the defendant wanted to vacate, the state would have said very clearly, you had the time to object and you didn't do anything. You sat on your hands.
I think, though, in light of the fact that it was the pandemic, one, and two, that it's an inaccurate reflection of what occurred, I think that it could have been filed even under, a Rule 60 to say that there was an error in there. I think that as officers of the court, in this particular matter, when a journal entry, does not accurately reflect what happened, especially during the pandemic, I don't think that the state would have said you sat on your hands. But I understand the argument. The time for objection had passed, and I cannot explain, what happened or whether, I couldn't in good faith say, well, the journal entry was not given to the state or the state didn't get it. I don't know. I know folks were working remotely. I cannot say what happened with certainty during that month.
My understanding, though, was that was an in-person procedure.
Right. But as far as the journal entries, when they got to the prosecutor's office or how they came through, I don't know. If there was some kind of delay, I have no idea in that respect.
Well, counsel, can you speak to why it would be under that in the juvenile court, the court would have some jurisdiction to go back in and make these changes? Is there some statutory authority for that?
To make the change to find that the journal entry was inaccurate?
To do anything with respect to a journal entry that has both closed the case and sealed the record?
Right. We would argue that that was basically an error. I mean, it's almost like just almost a typographical error. I mean, what was contained in the journal entry is just not an accurate reflection of what happened. So based on that, we would argue that the journal entry itself was a nullity, and therefore it could be vacated. And the sealing order is clearly a nullity. If the journal entry for the case, if that dismissal should not have been done, it was just the case was sealed under a statute that only relates to dismissals. So that certainly could be done that way. If there are no other questions, I would rest on the brief. I would just say, though, that Marcy's law clearly provides this victim with an opportunity to speak at sentencing or disposition. This is still going to be a case where the juvenile is going to go to diversion. The case will ultimately be dismissed, but this victim has a right under Marcy's law and under statute to speak, and that is what the state is asking to happen today. Thank you.
Let me just ask you a question in regard to that now. I understand, excuse me, I understand about the victim's rights and so forth. But if there is something that happens and the victim just is not notified, can you cite any authority that the remedy is always to overturn the conviction?
I don't think that the remedy is always to overturn the conviction when a victim isn't notified. But in this case, the journal entry does not accurately reflect what happened. And the victim was not notified and should have been notified. And in fact, had come to court every time he was notified.
Wouldn't there be more of a civil remedy for the victim?
There's absolutely a civil remedy for the victim as well. And I think with Marcy's law and the implementation language is still not set forth in statute. I mean, there could be a provision that says, that a plea could be overturned if a victim's not notified. And I think that that is the way things are heading, at least, in the criminal context. As far as, a juvenile delinquency case, I don't know for sure how it will come out, but I do believe that a victim absolutely has a right to be present at every hearing, and especially at a disposition in a case like this, where you're talking about a domestic violence situation with a stepfather who wants to be heard. And that's all we're asking for. And we're not asking for the conviction at all to be overturned. We're just asking for it to be remanded, for the journal entry to accurately reflect that this was a plea for a disorderly conduct, to dismiss the domestic violence, and to give this victim an opportunity to be heard. So we're not asking for any type of a conviction to be overturned at all.
Well, I understand that, but what you're asking for is for this court to overturn what is a journalized, basically, plea agreement that the state dismissed a case. The state dismissed a case, and then bringing the juvenile back and saying, now you're going to face an actual adjudication and a disposition and have something on your record.
Well, we disagree, I guess, with the characterization of what we're asking the court to do. We're asking the court to affirm the juvenile court's decision, where the court already vacated that decision, saying that there was a mistake.
I understand, but you're asking, she's asking us to overturn it, and you're saying, no, it's okay, that was legally done, and that's what I'm saying. So you're asking this court to affirm, causing a juvenile who had a case dismissed against him to come back to court and now be adjudicated delinquent by reason of disorderly conduct and have a disposition of that.
Correct.
Which
we are asking that the
juvenile
have the
which involves some kind of community. Go ahead.
I just couldn't hear you. I'm sorry.
Go ahead.
I was just going to say, we're just arguing for the disposition that the state and the defendant agreed upon to occur. We're saying that the original journal entry that came out was incorrect, and but there's no
record of what your agreement was.
Right.
So you're asking us to overturn, not overturn, but uphold something that there's no record of.
Right. Well, the defendant has the burden to show that the trial court erred when it granted the state's motion. So the things that are in the state's motion should therefore be accepted as true. The trial court's journal entry vacating the dismissal and the sealing should be treated as no error occurred under the case law. The journal entry speaks through itself, and that the defendant has the burden to bring forth any evidence to the contrary. And with that, I would rest on the brief if there are no other questions. Thank you.
Seeing none, thank you. Counsel, you have 5 minutes for rebuttal.
Thank you, Your Honor. So first of all, if the state is claiming that the magistrate's decision is not a true recitation, the state has the burden of producing evidence on that. The state could have ordered a transcript of that hearing. The state could have filed an affidavit, but simply putting into a motion is not sufficient. And the motion to vacate cannot be used as a substitute for objections, timely objections to the magistrate's decision. Also, Your Honors, the claim that the trial court has ruled on the state's motion to vacate is incorrect. The trial court cannot rule on that motion because that case is gone, that case is dismissed, and that case is sealed. There was no motion pending in July of 2021 when the trial court supposedly ruled on that motion. It was presumed denied by virtue of the fact that the trial court had dismissed and sealed the case.
Counsel, let me just ask you the same question I asked the state's counsel, and that is in regard to Marcy's law, in regard to the fact, a victim does have a right to be there. I don't think that's anybody's, I don't think either one of you are contending otherwise. So what is the remedy if for some reason a victim is not notified?
So first of all, and thank you for that question. I was struggling to remember what I was going to say. And this is what I wanted to point out, Your Honor. We don't know that the victim wasn't notified. And the victim has a right to be notified of what and to what extent. So this is a victim who's been participating, who's been in contact, not only with the state of Ohio, but with the child, the juvenile, who's at issue in this case because it's a family member. There's nothing in the record that says that the alleged victim in this case was not notified. What we know is he did not appear for that day. And I understand it's captioned as a file review. And it may be that he wasn't notified. But the state has presented no evidence to actually show that. They're making that assertion or assumption. It could be a victim is notified and chooses not to attend. Happens more often than people actually attending. And particularly whereas here, the family wanted to move on and the family had decided how to proceed. And that's what was memorialized in the court's order. And while there are remedies, the remedy under Marcy's law will never trump due process rights of the accused. And Marcy's law is really a process law. It's a process for victims of crimes. It's not a substantive body of law that somehow trumps the constitutional rights of the accused. And in order for the trial judge to unseal the case, undismiss the case, put NK back into square one where he now stands accused of a domestic violence offense, which is enhanceable. In order for all of that to happen, we would have to unravel centuries of due process for the accused. And that is not what Marcy's law stands for either. So, Your Honors, with all due respect to the state of Ohio, whether or not they notified this victim is between them and this victim. It is not part of the record. There's been no other facts made part of the record. and the court speaks through its journal entry. And I'm asking you to reverse the juvenile court judge and order that the case be dismissed and sealed as it was. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties as well as posted on the Ohio Supreme Court website. Thank you also for agreeing to appear via video oral argument. The next oral argument this court has is set for Thursday, April 1st. Again, thank you. Have a great day.